I'm Adam Cohen, a partner in Eversheds Sutherland's tax group.
And I'm Ryan Session, an associate, and also in Eversheds Sutherland's tax group.
Today, we're going to talk about an important and interesting development under the Tax Cuts and Jobs Act, which is the potential deduction disallowance for client and customer meals. The Act denied a number of deductions that Congress viewed as potentially subject to abuse or possibly not achieving the intended tax benefits, and one of these was the deduction denial for entertainment expenses. So Ryan, do you want to talk a little bit about what this looked like under prior law?
Sure, Adam. Under prior law, Section 274A generally disallowed deductions for entertainment expenses, but it included a significant exception where the entertainment was associated with or related to a business activity. This exception often applied where taking a client or a customer out to a meal, which was generally considered entertainment. But even where this exception applied, Section 274N provided a 50% limitation for food or beverage expenses of 50% of the total cost.
So the Act made a very significant change in this area by eliminating that exception for activities that were expenses that were associated with or related to a business activity. And so as a result, meals that are considered entertainment going forward would be 100% non-deductible, whereas meals that are not considered entertainment would still generally be subject to the 50% deduction disallowance. So there's two views on whether meals are considered entertainment with customers or clients, which is a very key question. And the first view would be that meals with customers and clients just by their nature are always going to be entertainment because meals are always entertainment. Another view is that meals that are in a setting that's conducive to business discussions, like a quiet restaurant with music, without music, or other entertainment in the background, should not be considered entertainment. It may also be relevant whether there's business discussions going on during the meal. And so Ryan, what should employers be considering right now?
Well, until we have further guidance, employers may want to ensure that they have a system in place to determine the characteristics of any client or customer meals. For instance, they may want to ensure whether there was any additional entertainment activities, such as music, or if there were actually any business discussions.
Yeah, so we may actually get some guidance on this later in the year in the form of Joint Committee on Taxation Blue Book wording or potentially IRS interpretations. But in the meantime, employers should be aware of this issue and thinking about putting processes into place to manage around it and document what's going on. So thank you very much for joining us today. If you'd like more information about the Tax Cuts and Jobs Act or would like to view additional bottom line videos, please visit eversheds-sutherland.com.